I'm Rich Lowry, editor of National Review and host of our podcast called, funnily enough, The Editors. Every week on The Editors, I discuss with my colleagues the latest news and national controversies. We cut through the cant, get beyond the lies and spin, and provide insight and facts you're not going to get anywhere else while having a good time doing it. In this era of folly, myth, and hysteria, you owe it yourself to check out The Editors. You can find it on Google Play, Stitcher, TuneIn, and iTunes. We hope to see you soon. Welcome to the McCarthy Report, the podcast where I, Rich Lowry, discuss with Andy McCarthy the latest on the Mueller report and other legal and national security issues. This week, Hope Hicks, the Manafort ledger, the Assange indictment, and the Supreme Court on dual sovereignty. You're listening to a National Review podcast. If you're listening to this podcast on nationalreview.com, we're delighted to have you. It'll be easier for you and better for us if you made us part of your feed at Google Play, Stitcher, TuneIn, or iTunes. And please give this podcast and Andy McCarthy the glowing, nay, embarrassingly gushing praise they deserve in an iTunes review. And now, without further ado, I welcome to this very podcast through the miracle of Skype none other than Andy McCarthy.
Hey, Rich, underscore embarrassingly. I like that. I like that new embellishment on the intro. That's great.
So we had a lot of coverage the last couple of days of Hope Hicks' closed-door testimony. I'm not sure exactly why Hope Hicks is believed to be the crux of some vast conspiracy that's bound to be unearthed, but she didn't talk about a lot of things, which has the Democrats upset. So what's going on here?
Well, Rich, I think they want her because even though she didn't seem like a very important figure, I think she's mentioned well over 100 times in the Mueller report. And what they, I think, mainly wanted to home in on with her is she is a key participant in the statement that President Trump put out about on the plane about the Trump Tower meeting. So I think that's the main thing they want to ask her about. But the problem they have is they run straight into real areas of recognized presidential privilege. And what the White House has asserted with some legal guidance from the Office of Legal Counsel at the Justice Department is not only that because she's a member of the president's staff. And so the president's staff, top staff advisors, not only does executive privilege come to the fore, but there's a doctrine that hasn't really been tested by the courts that says that they have absolute immunity from testifying about their the conduct of their duties as advisors to the president. And the idea behind that doctrine is that if they were forced into the position of having to testify, they could accidentally or inadvertently compromise information that could be privileged under executive privilege. So the idea is that they're such high advisors, and the things that they're involved in are so weighty that even executive privilege doesn't do the trick as far as protecting what needs to be protected. They have immunity even from testifying. So she basically, in a blanket way, as I understand it, just said, I am not going to discuss anything in connection with my duties as, I think she was like the strategic communications coordinator, and then she was the top communications person for a while. So she just refused to discuss any of that, and they were reduced to just asking her about things about the campaign, which I don't think are all that relevant.
Right. And so is this a model, or does this show them how they could actually get some testimony from people like Christie and Lewandowski that wouldn't be subject to immunity or executive privilege claims?
Well, it does put them in a position where if they want to bring in people who are not going to be just totally frustrating to deal with, The Trump administration has signaled, and I should back up and say there's an interesting dance going on here on both sides. The Trump administration has signaled that they are not going to allow the congressional Democrats to have the same access that they gave to Mueller. And what the president is saying here is, look, I didn't waive executive privilege. I didn't waive any of my privileges, but to show good faith, I made a lot of information available to the special counsel that I didn't have to make available. I could have asserted all these privileges. And what did I get for my troubles? You guys now just want a second bite at the apple. So that's the end. I'm not cooperating anymore, and I'm asserting all of my privileges. And if you don't like it, I'll see you in court. Mm-hmm. And I think he's doing that because he knows that Pelosi doesn't want to see him in court. And that's the interesting dance that's going on the other side of this equation. Pelosi knows that she has these vulnerable Democrats who are in seats. I think there's 41 of them or so who are in seats that Trump is popular in, and I think that Trump carried, or at least came close to carrying, but I think he did carry in his election in 2016. And she knows, Rich, that aside from protecting them, she's really, the chess game that she's playing is the Democrats win the White House in 2020, but if they win it in a way that has so angered the voters in those districts that the House flips back to the Republicans, it's going to be a very frustrating 4 years for whoever the Democratic president is. So I think from Pelosi's standpoint, she sees 2020 as a winnable election, and one where she would like to be able to deliver not only the White House, but deliver a House majority, especially under circumstances where, at least now, I think it looks like the Republicans probably hold the Senate. So she doesn't want to be going to court. And she certainly doesn't want to be in a situation where they have to have votes in order to go to court. So a couple of weeks ago, they did this kind of fugazi procedure that they've now come up with, where the chairman of the main investigating committees in Congress are now allowed to go to court on their own if they get a green light, basically from Pelosi. If they get a green light from a 5-person committee of the bipartisan leadership of the House, 3 Democrats, including Pelosi, and 2 Republicans. And the reason that she set that up is because ordinarily, to enforce a House subpoena or to do something like hold an administration official in contempt, they would have to have a vote of the full House. And I think she is going the extra mile to try to spare those 41 Democrats having to take any votes that she can avoid them having to take that would put them in a position of voting against Trump under circumstances where the people in their district, unlike the people in, say, New York and California, most of the places that are real Democratic strongholds, the people in these districts, I think she has a sense that they are ready to move on from Mueller. They wanted to hear what Mueller had in this investigation. They've now gotten it, and they want to move on to – they're not saying they love Trump, but they want to move on to dealing with, the various other issues that the country has to grapple with. And they've had it with Russia, and they've had it with collusion and obstruction and everything else, and they don't want to hear about it anymore. And they're sympathetic to Trump. So she's trying to spare them the need to vote, and she's trying to, I think, to the extent that she can, she realizes that they're never going to impeach Trump. So what she wants to do is play out this next 17, 18 months and try to defeat him next November and try to hold it together under circumstances where her base, which is the energy and the money in the party, really want to impeach Trump. So it's a tough dance for her.
And then how about this deal between Nadler and Barr over some of the underlying documents in the Mueller report? I mean, one reason that the claims of a constitutional crisis from Nadler and from Pelosi were ridiculous is was clearly a negotiation going on of the sort that's happened many times before between the executive and the legislative branches, and here you had some give and a deal.
Yeah, that's exactly right, Rich. And the give is not at all surprising. So what I understand that Barr did in the negotiation is he told Nadler that they can have access to what are known as the FBI 302s, which are the witness interviews, so that if you sit down with a prosecutor and an FBI agent to do a voluntary interview, the FBI writes up a report of the interview. That's the 302. So what they're saying is, yes, you can have the 302s, and yes, you can have any notes that the witnesses made. And those are exactly the kind of things, Rich, that defense lawyers get in criminal proceedings. When the government indicts you and they have to give discovery and the case goes to trial, you have to give the defense lawyer all of the underlying witness statements and that sort of thing. So what Barr is giving up is really not much. It's the kind of thing that you would give up if there were a trial. And under these circumstances, we now have a report from Mueller and no reason to think that there's anything that's particularly spectacular or notable in any of these FBI reports or any of the notes of the witnesses or what have you. The chance that there's anything that's significant in that information that Mueller didn't include in his 448-page report is really remote. But in the meantime, what Barr didn't give them was the grand jury material, which, again, is material that by law he can't give them. So even in this negotiation, he did not yield on that. And the position he therefore puts Nadler in is if Nadler were to try to run to court and either hold Barr in contempt or try to get him to produce whatever he hasn't produced yet, he would have to explain to a judge why he would be interested in compelling Barr to turn over information that it's illegal for Barr to turn over. And he would have to explain to the judge, since Congress has it within its power to change the grand jury rules so that the Justice Department could disclose the grand jury material to Congress, why is Congress coming to the district court? Why doesn't Congress just pass a law that makes Barr give him the information? So Barr knows Nadler doesn't want to go to court on that case. It'll be a rout. So it's very interesting that there's a kind of a public dance that's going on that is sort of being choreographed to suggest to the public that there's something really serious about impeachment and contempt and all that nonsense that's going on. Whereas behind the scenes, I think they're basically getting the information they need or want. And at the bottom of it all is Pelosi, who knows that this is a bad idea to be pursuing it and is trying to do just enough so that she doesn't get mutiny from her base, but in the meantime trying not to screw up what she sees as a winnable election in 2020.
Right. So let's move on, Andy, to the Manafort ledger. And this is distressing for me because I was just really getting up on all the ins and outs of the Steele dossier. And now I learn there's an entire different document called the Manafort ledger that I had no idea existed that may be an element of the story that I'm going to have to learn about, or at least listen to you about, and go on my merry way.
Well, Rich, I'm going to bet that you really have heard of the ledger. It's just we haven't thought of it in terms of.
So is this the list of payments, the handwritten lists?
Exactly.
Okay.
Yes.
So I remember that from 2016. I flipped through the ledger at some point.
Yeah. Well, we're starting to think about the ledger in terms of, or in the same way that we think about the dossier, because, when we got the ledger and all the reporting about the ledger, the assumption that everybody had was that the ledger was true, because the ledger merely stated in black and white something everybody had reason already to know, which was that Manafort had done a lot of work for the Ukrainian Party of Regions and for the Yanukovych administration, Yanukovych being the main client who ruled Ukraine for about 4 years beginning in 2010. So since the ledger just said that Manafort got a lot of money from Yanukovych, everybody figured, well, of course he did. We knew that. But the interesting thing about this document is that its provenance has never been established. Its authenticity has never been established. And now what we're hearing from the authorities in Ukraine is that it may very well be a fake. They won't stand behind it being a real, authentic document. So naturally, people are saying, well, where does this come from? How did this, how did this thing come into existence? And what we learn is the FBI actually learned about it in 2014 after Yanukovych flees to Moscow. And this, Rich, remember, is the Euromaidan revolt in Ukraine at the beginning of 2014. It's a very interesting time and a very interesting situation because the Obama administration throws its support behind Poroshenko and the new government after Yanukovych is blown out of there. And they become very financially dependent on the good grace of the Obama administration. They need a big influx of money from the International Monetary Fund that the Obama administration backs. And Joe Biden, and this is part of the reason I think we're going to be hearing more about this, Vice President Biden becomes basically the Obama administration's point person for dealing with Ukraine. And Biden puts a lot of pressure on Poroshenko to fire a prosecutor in Ukraine. It turns out that the prosecutor at that point is investigating, he's got a corruption investigation on a big Ukrainian energy company that just happens to have put Biden's son on its board of directors. And Biden's son's firm gets paid something in the area of like $3 million over about a year and a half in that role. And when the prosecutor in Poroshenko's government is looking at that company, Biden leans on Poroshenko, and Poroshenko does in fact end up firing the prosecutor, and the investigation of the company seems to go nowhere. Around the same time, the Obama administration, in order to help Ukraine with their application to the IMF to get this money, among other reasons, encourages them to establish what ironically they call their anti-corruption bureau. And the Anti-Corruption Bureau ends up having, as you would expect, close relationships with the FBI and the other Obama administration agencies. And one of the things they're looking at that point in time is all the money that went out of Yanukovych's government, including the money that went to the Party of Regions, which of course the new government is opposed to. And that's when this ledger emerges, which supposedly shows. Now, it doesn't emerge publicly, but the Ukrainian Anti-Corruption Bureau lets the FBI know about it, and ultimately, the Obama administration at that point in time, this is 2014, they decide to close the investigation. The Justice Department does of Manafort without charges. And Manafort, by the way, always takes the position that he didn't get cash from Yanukovych, that there's lots and lots of money that changed hands, but it all went by wire transfer to accounts that Manafort controlled. So he's denied the ledger from the beginning. The Obama Justice Department drops the investigation in 2014, and I note that at the time they dropped it, to pursue that investigation would have meant pursuing Greg Craig, who had been Obama's White House counsel, and Tony Podesta, the brother of John Podesta, who runs the consulting firm that the Podesta brothers started all those years ago, who both Craig and Podesta had been cut into the Ukrainian work by Manafort. So it wouldn't have been practical to just investigate Manafort for possibly violating the Foreign Agency Registration Act and other provisions and not investigate those guys. So they just end up dropping the whole thing. So what happens 2 years later? Well, Trump cruises to or is cruising to the Republican nomination, and Manafort is getting on board the Trump train, right? So at that point, all of a sudden, the Obama administration becomes very interested in reopening or having the Ukrainians reopen the investigation into the money that went from Yanukovych to Manafort, or at least supposedly. And that's when the ledger rears its head again, and the ledger actually ends up being leaked to the media by not only the head of this anti-corruption bureau, but also a legislator in Ukraine named Serhiy Lyshenko. And Lyshenko is an interesting character because he's very public in his support for Hillary Clinton. Good for Hillary that she got the Kiev vote locked up. I think, Wisconsin might have helped her more, but in any event, this guy is like a big Hillary guy. His big backer financially is Victor Pinchuk, who's a major donor to the Clinton Foundation. So anyway, he ends up being among the people who leaked this information to the media. The ledger, of course, is what ends up, once it gets reported, it ends up getting Manafort ultimately blown out of the Trump campaign. It also becomes a big foundation for the collusion narrative, and it becomes part of the engine for the prosecution of Manafort, even though it doesn't. The ledger itself, the payments supposedly recorded in the ledger, are not crimes in the Manafort indictment, but they are a big trigger for Mueller's investigation into the monies that got paid by Ukraine to Manafort and lead to a lot of the charges that end up in the indictment against Manafort. But nobody can prove that the ledger is authentic. And P.S., what we now know, based on the testimony of people like Nellie Orr in the congressional proceedings, Nellie Orr was this woman who was a CIA researcher. She's married to Bruce Orr, who was the top Justice Department official who dealt with Steele on the Steele dossier. And Nellie was also working at Fusion GPS, which is the outfit that basically the Clinton campaign used to generate the Steele dossier. Well, it turns out that according to Nellie's testimony, this Ukrainian legislator, Serhiy Lyshenko, was actually an informant for Fusion GPS at the time that this ledger got leaked. So it's very interesting. It's the subject of a lot of investigation in Ukraine. We don't know at the moment whether it's the subject of much investigation here, but I imagine that's something we'll find out in the coming months.
Who would have guessed that one of the paths of American presidential politics, 2 cycles running, would go through Ukrainian,
it's amazing, isn't it?
Ukrainian scheming.
Yeah, it's amazing. But the interesting thing is there's a lot more solid evidence of Clinton campaign collusion with actual government officials in Ukraine than there is of Trump campaign collusion with Russia, a lot of which was the imagination of Christopher Steele. I'm not saying that there aren't contacts. There obviously were contacts between the Trump campaign and Russians and Russian people who have connections to the Kremlin. But this is actual collusive behavior between what appears to be the Clinton campaign and government officials in Ukraine that was clearly intended and actually probably did have an impact on the election.
Yeah. So Julian Assange, let's do a little catch up and get your take on this much wider ranging indictment. The last time we talked about it, he had been kicked out of the consulate or embassy, I guess, in part because his cat wasn't very tidy. And actually, when we saw him in real life, he was not looking as though he was leading the most cleanly guy to have in your.
They'll have to ask Pamela Anderson about that.
Yeah, exactly. Right. But anyway, so initially there was the count having to do with allegedly trying to help break the password for Bradley Manning, and now that was, I guess, 5 years potentially. Now you're looking at 175-year exposure. There are all these other counts, but does it go to the same core offense?
Yeah, Rich, this goes to show what prosecutors can do, which is why people get all whipped up about this kind of stuff. This really isn't an indictment that expands the case against Assange in terms of time and space scope. Basically, what it's done is it's taken the same scheme that the result of which was this one count indictment that was filed in March, and then fast forward to, I guess it was late May when this finally came to pass. They supersede the indictment, so what was one count is now 18 counts, but it's still arising out of the same transaction, which is this 2009-2010 conspiracy between Assange and the person who's now Chelsea Manning, then Bradley Manning, to get access to this information through Manning's security clearance and access to classified information. Assange encouraging Manning to get this information, helping Manning break into whatever needed to be broken into to get more access, and then get the information shipped to Assange so that he could do his thing and get it disseminated. And it's a tremendous amount of information. I mean, it's basically just the State Department cables alone, I think, were 250,000 documents. Mm-hmm. There's about 90,000 incident reports from Afghanistan, about 400,000 incident reports from Iraq. So there's a lot of information here that's sensitive, and it's classified. It's not top secret classified, but it's classified at enough of a high level that it's disturbing. But it's still the same transaction. It's not. It hasn't changed from one indictment to the next. So what I would continue to underscore here is a couple of things. Number one, they have totally skipped over collusion with Russia, which is the main thing that we've been looking at Assange for the last, 3 or 4 years. And if you read Mueller's indictments, Assange is clearly a co-conspirator of the people who hacked the DNC and got that information out. So you have to ask yourself, why are they reaching for this Manning conspiracy from almost a decade ago when the big thing on Assange that we've been looking at for the last 3 years is collusion with Russia. And I continue to think it's because they know that they would not be able to prove in court that Russia is responsible for the hacks. Now, again, I always have to qualify this when I say this. I am not saying Russia didn't do it. I'm saying that there are some things that are true in life that can't be proved in court, either or both, because the evidence that would be necessary to prove it is not available to be used in court because of other considerations like national security considerations, the fact that they may blow, methods and sources of intelligence that we don't want to publicize. And here I think there's also the fact, and it's a disturbing fact, that if you were to try to prove this in court, you would have to rely on CrowdStrike, which is the outfit that the private outfit that is a very blue Democratic outfit with a lot of Democratic heavy hitters attached to it, that the Democrats retained in order to do this, the security analysis on their server system, in lieu of allowing the FBI to investigate and to do forensic testing on their servers. So you would have to go to court without the FBI having acquired and done its own testing on the main evidence in the case, which is not a position you want to be in if you're the government trying to prove a conspiracy. So, number one, I continue to think it's very curious that they haven't indicted Assange for collusion with Russia. And number two, I don't know how they're going to make this superseding indictment against Assange fly, because the first indictment they filed, I think, already had major problems as far as the statute of limitations is concerned. The statute of limitations on whether it's the Espionage Act or the hacking statute is generally 5 years. They have tried to bring it under an 8-year statute of limitations based on a 3-year extension for acts of terrorism. So I think they're going to have a hard time showing that this is related to some kind of an act of terrorism. And even if they can show that for the original indictment that was brought within the 8-year period, we're now outside the 8-year period. This superseding indictment is from 2019. It was just returned in March. Or I'm sorry, in May. So, I don't know how they're planning to make this fly. And at this point, I'd really be surprised if the British courts agree to extradite Assange on the basis of this, let alone whether he'll ultimately ever face an American prosecution.
Okay, last thing before we go. You're ginned up by this Supreme Court decision upholding an exception to double jeopardy.
Yeah, the dual sovereignty doctrine, the Supreme Court upheld that this week. There's been a lot of commentary about this, Rich, over the last the case has been on the court's calendar for the whole term, and there's obviously been a lot of commentary about it, and it's a bad time to be arguing for provisions in the law that give prosecutors more options and allow more prosecutions and the addition of more years. I know you've been talking about the 1994 crime bill, which is under some assaultive commentary at the moment, and this is the same sort of thing. The dual sovereignty doctrine allows a person to be prosecuted twice for the same crime, and the theory behind it is that if you commit a violation of law that violates the laws of two different places, two different governments, that even though it's only one crime, you haven't committed one offense. You've committed two offenses. You've committed an offense against the criminal code of both jurisdictions. And in the United States, our theory is that the states are a separate sovereign from the federal government. So if you commit a violation of law that violates the laws of a state and you get prosecuted by the state, whether you get convicted or acquitted, the federal government can turn around and indict you for the very same conduct, and you can't plead double jeopardy, because double jeopardy can only be pled if you are subject to a prosecution for the same crime by the same sovereign a second time. It's an issue that's of interest to me because it came up an unusual number of times in my career. I'm sure that most people who are prosecutors for any length of time probably go through their entire careers without ever dealing with dual sovereignty, because it's a situation where the Justice Department frowns on multiple prosecutions for the same offense, And even though legally you're allowed to do it, Maine justice usually will not let federal prosecutors do it. But I was permitted to do it 4 times over the course of 20 years. Most notably, I think, in the blind shake prosecution, we prosecuted Saeed Nosair for murder in connection with the murder of Meyer Kahane, which was one of the more famous murders of the second half of the 20th century. Nosair, who was a major figure in the blind shakes terrorist cell in New York and was also involved in the planning of the 1993 World Trade Center bombing, a lot of which was planned from his prison incarceration in Attica in upstate New York. But in 1990, Nosair murdered Meyer Kahane at the conclusion of a speech that Kahane gave at a Marriott hotel in Midtown Manhattan. He did it in a very brazen way. He basically snaked his way into a crowd of people who were around Kahane right after the conclusion of a speech, shot him in front of all those people, and then fled out of the room by basically, there was a big, strong 73-year-old guy named Irving Franklin who tried to block Nosair from leaving the room, and Nosair shot him and then basically ran over him to get out the door. He was expecting when he got out in the street to be picked up by his friend Mahmoud Abu Halima, who later would bomb the World Trade Center, was one of the bombers. Abu Halima drove a yellow cab, and that was supposed to be the getaway car. But when Nosair got out to the street, there were a bunch of yellow cabs, and he couldn't pick out the right one. So he hopped into the nearest one and
he has the opposite of the problem most people have in New York. If you really need a cab, you can't find one.
Right. He had too many. Right. He had too many. So anyway, he jabbed his gun at the back of this driver's neck and told him to step on it. And, of course, he's being pursued by this crowd of Kahane supporters who are also flying out of the hotel after him. The cab driver comes to a red light, slams on the brakes as Nosair is lying on the back of the passenger seat trying to hide from people who are pursuing him. The cab driver jumps out of the cab and points at the back of the cab at Nosair, so he jumps out and bolts. One guy comes up close and it looks like he might be able to tackle him, but Nosair waves the gun at him and the guy backs off. And then Nosair starts running up he's on 5th Avenue between 47th and 48th Street, and he comes face to face with a guy who turns out to be the hero of the piece named Carlos Acosta, who is a uniformed postal police officer. It was 9 o'clock, and he just happened to be closing the 5th Avenue postal office. So he gets within about 9 feet of Nosair, and he gets into a stance to shoot in order to try to protect himself and present a smaller target. Nosair shoots at him when he tells Nosair to freeze and hits him in the chest. But fortunately, Acosta is wearing his bulletproof vest. So the round actually deflects from the area near his heart up into his shoulder. Nosair, in the meantime, takes another shot, which whizzes by Acosta's ear, but misses him. And then Acosta's able to return fire and take Nosair down.
Wow, what a story.
Yeah. So, and it ends up, Rich, being a terrible trial. Bill Kunstler told me years later, Bill Kunstler represented Nosair in the state trial, which was a zoo, and then ultimately tried to represent Nosair and the blind sheikh in our case later on. He ended up being disqualified because he had too many conflicts, because he had too many clients in the terrorist organization. But Bill told me years later that he thought he had won the case in jury selection. And it sure sounds like he did, because it was a crazy verdict. They acquitted Nosair of these 3 shootings that he did, in cold blood right in front of people, but convicted him of weapons possession charges, the weapon that was shown to have been used in all 3 of the shootings. So it was a verdict in the state that was against reason and against the weight of the evidence. But they were acquittals. I mean, he was acquitted of the main charges. And we ended up indicting him for murder and attempted murder in aid of racketeering in the Blind Sheikh case. And we had some argument about whether we should bring the case or not, as you always do when you have this situation. But we were in the unusual situation where we had a separate federal interest in bringing the prosecution because while the state has a strong interest in public safety on the streets of its communities, the federal government has a strong interest in policing and protecting the country against international terrorism. So our prosecution actually served a separate federal interest. And the other thing about the incident, Rich, is we needed to be able to prove to our jury why Nasser had become such an influential figure in the pantheon of jihadist heroes that he was now able to be cut in on secret planning, to command acts of terrorism, to help them with fundraising, to help them with recruiting. We wouldn't have been able to show that without proving what he had done to become an iconic figure. So we would have had to prove the Kahani homicide, regardless of whether we were allowed to charge it or not. And if we had proved it without being able to charge it, and the defense had been able to show that he had been acquitted by the state, we would have been at a real disadvantage. So it didn't make any sense for us not to charge him, and we ultimately did, and fortunately he was convicted in the federal trial.
Great. Well, that's all the time we have today. You've been listening to a National Review podcast. This podcast has been produced by the incomparable Sarah Schutte. Thanks, everyone, for listening, and thank you, Andy McCarthy.
Thanks, Rich.